Imagine walking into a room knowing that your every move is being recorded, not for security, not for your protection, but so the people you're investigating can study your methods, anticipate your questions, and prepare their defenses before you even ask. Now imagine you're a member of the United States Congress, constitutionally empowered to oversee the executive branch, and the room belongs to the very agency you're supposed to be holding accountable. Every file you open is logged. Every name you search is recorded. Every inquiry you make is tracked and compiled into a dossier that will be used against you. This isn't speculation. This isn't conspiracy theory. This is exactly what's happening right now as lawmakers attempt to investigate one of the most disturbing criminal enterprises in modern American history. The Department of Justice, the institution charged with upholding the rule of law and ensuring equal justice for all, has constructed a surveillance apparatus aimed not at criminals or terrorists, but at the elected representatives of the American people. Members of Congress seeking answers about Jeffrey Epstein's sex trafficking network, about the powerful men who enabled and participated in these crimes, about the institutional failures that allowed this horror to continue for decades, are finding themselves monitored, tracked, and obstructed at every turn. The agency they are investigating knows exactly what they are looking at, which documents they find most interesting, which names they are researching. And when the Attorney General appears before Congress to answer questions, she arrives armed with intelligence about what her interrogators have been studying. This is not how democracy is supposed to function. The Constitution establishes 3 separate and co-equal branches of government, specifically to prevent the concentration of unchecked power. The legislative branch oversees the executive precisely so that no president, no cabinet official, no agency director can operate above the law or beyond scrutiny. But oversight only works if it is genuinely independent, if investigators can follow leads without those they're investigating watching over their shoulders, anticipating their moves, and preparing counter-strategies. What we are witnessing now is the deliberate corruption of that oversight process, a systematic effort to know what Congress knows before Congress can use that knowledge, to stay one step ahead of accountability by turning the tools of investigation inward against the investigators themselves. The story begins with a law, but like so many stories about justice in America, the distance between what the law requires and what actually happens is vast and telling. The Epstein Files Transparency Act was passed after years of advocacy by survivors and their allies who refused to accept that Jeffrey Epstein's death meant the end of accountability for his network of enablers and accomplices. The law was straightforward in its intent. Government agencies holding documents related to the Epstein case were required to release them to the public. Redactions were to be limited to protecting victim identities and legitimate national security concerns. The American people who had watched in disgust as Epstein received a sweetheart plea deal in 2008, who had seen him continue socializing with presidents and princes and billionaires despite his conviction, who had witnessed his suspicious death in federal custody just as he was finally facing serious charges, deserved to know the full truth. When files were initially released, the betrayal was immediate and obvious. Survivor names appeared unredacted, exposing women who had already endured unimaginable trauma to potential harassment, intimidation, and further violation. Meanwhile, the names of powerful men, the alleged perpetrators and knowing facilitators of these crimes, were carefully blacked out. This inversion of the law's clear intent revealed everything anyone needed to know about whose interests were being protected. Not the victims, not justice, not the public's right to know. The interests being protected were those of the elite, the connected, the men who could afford the best lawyers, and who had the right phone numbers, and who understood that in America there are 2 justice systems, one for ordinary people and one for them. Congress was not satisfied with this selective disclosure. Lawmakers from both parties demanded access to the unredacted versions. They have security clearances. They have constitutional authority. They have a duty to ensure executive agencies operate lawfully and in the public interest. After initial resistance, the Department of Justice agreed to make unredacted files available for congressional review. But the process they established reveals that their goal was never genuine transparency. It was the appearance of cooperation while maintaining complete control over what Congress could effectively learn and how they could use that information. Here is what members of Congress face when they attempt to review these files. The Department of Justice has designated a single secure location for document review. It is not in the Capitol complex where lawmakers work. It is in a separate DOJ facility, requiring members to travel to the domain of the agency they are investigating. 4 computers have been set up in what multiple lawmakers describe as a cramped, uncomfortable room. Members must schedule appointments for limited time slots, typically 30 minutes to 1 hour. Given that the document collection runs to millions of pages, these time constraints make comprehensive review virtually impossible. But the restrictions on time are not the most troubling aspect of this arrangement. Each member of Congress is assigned a unique username and password to access the system. On its face, this seems like a reasonable security measure. Different people need different credentials. But those unique logins serve another purpose, one that lawmakers are only now beginning to fully understand. They allow the Department of Justice to track exactly which representative is looking at which documents, which search terms each member enters, which names they research, which files they find significant enough to spend their limited time reviewing. The agency being investigated has constructed a surveillance system that monitors the investigators in real time. Congressman Raja Krishnamurthy, a member of the House Oversight Committee, has been through this process firsthand. In recent interviews, he described the growing realization that his activities were being logged and analyzed. The confirmation came during Attorney General Pam Bondi's appearance before the House Judiciary Committee. Photographers captured images of Bondi with documents that appeared to contain records of searches conducted by committee members. Think about the implications. The Attorney General, summoned to answer questions about why no one beyond Ghislaine Maxwell has been charged, about why survivor names were exposed while perpetrator names remained hidden, about why the department is not complying with the transparency law, walked into that hearing room with intelligence about what her questioners had been researching. She knew which documents they had reviewed. She knew which names they had looked up. She knew which aspects of the case had drawn their attention and which they had not yet discovered. This gives her an overwhelming advantage in evading accountability. She can prepare specific answers for specific anticipated questions. She can redirect attention away from areas she knows they haven't fully explored. She can identify weaknesses in their knowledge and exploit those gaps. This is not a witness being questioned by independent investigators. This is a chess match where one player can see the other's strategy several moves ahead. If this were happening in a criminal investigation, if prosecutors discovered that the target of their probe had been monitoring their case files and tracking their investigative activities, the case would likely be thrown out. The compromise would be too severe. Evidence could be tainted. Witnesses could be intimidated or coached. The entire integrity of the investigation would be destroyed. Yet when it happens to Congress investigating the executive branch, we are told this is normal procedure, necessary security measures, nothing to be concerned about. The brazenness of it is staggering. The surveillance is only one layer of obstruction that lawmakers face. Congressman Krishnamurthy detailed a series of restrictions that seem designed not to protect sensitive information, but to make effective oversight impossible. When he first entered the secure room, he brought printed copies of emails that had been previously released with redactions. His intention was simple and logical. Compare the redacted versions to the supposedly unredacted database and see what had been hidden. This is basic investigative work, but DOJ personnel told him he could not write on the printed emails. Notes had to be taken on separate paper. Adapting to this rule, the congressman began using sticky notes to mark important passages and keep track of which notes corresponded to which documents. The next day, he was informed that sticky notes were no longer permitted. So he switched to writing notes on small pads of paper and tearing out individual sheets to organize them with the relevant materials. This, too, was prohibited. All notes must remain in a bound notepad, making it nearly impossible to organize information, to place notes next to corresponding documents, to visually map connections across multiple files. These are not security protocols. These are deliberate handicaps imposed on investigators to ensure they cannot effectively synthesize the information they are reviewing. According to the congressman, the DOJ staff enforcing these rules were courteous and professional, but clearly operating under strict orders from leadership. The message was unmistakable. You can look at the files, but we will make it as difficult as possible for you to understand them, organize them, remember them, or use them to hold anyone accountable. This is malicious compliance, following the letter of the law requiring access while violating its spirit through procedural sabotage. The technical limitations compound the problem. The database containing the files lacks functional search capability. A lawmaker can enter a name or term and receive some results, but once a document is opened, there is no way to search within it to find where that name or term appears. Picture trying to read a 100-page document looking for a single reference without being able to search for it. Now multiply that across millions of pages, with the clock ticking on your limited appointment time, with restrictions on how you can take notes, with the knowledge that your every search is being logged and will potentially be used to prepare defenses against your future questions. When asked about specific types of documents that survivors and investigators consider crucial, Congressman Krishnamurthy reported that FBI 302 forms, which are detailed reports of witness interviews, were either entirely redacted or simply absent from the database. Court filings from Florida and New York that are part of the public record remained redacted even in the supposedly unredacted version. The department's explanation is that these documents came to them already redacted. But this defies logic and law. The DOJ has full authority to obtain complete court records. They have the power to compile comprehensive files. The Epstein Files Transparency Act specifically requires them to do so. The fact that they have not, or claim they have not, is itself a form of obstruction. The pattern is consistent and revealing. Information that would protect the powerful is withheld. Information that exposes the vulnerable is released. Processes that would enable effective oversight are crippled. Systems that would allow the executive branch to monitor Congress are implemented and exploited. This is not bureaucratic incompetence. This is strategic obstruction, executed by an agency that understands it is supposed to be accountable to Congress, but has decided it will not be. The Attorney General's recent appearance before the House Judiciary Committee crystallized the dysfunction and the contempt. Survivors of Epstein and Maxwell's crimes attended the hearing. These are women of extraordinary courage. They were victimized as children. They were disbelieved and dismissed when they first tried to report what was happening. They watched their abusers face minimal or no consequences. They have fought for years against institutions and powerful individuals who wanted them silenced to bring some measure of truth and accountability. They came to the hearing hoping to see the nation's chief law enforcement officer demonstrate that their suffering mattered, that justice was a priority, that the system would finally work for them. At one point during the proceedings, the survivors stood. They raised their hands. They sought acknowledgement from Attorney General Bondi. She looked away. She did not make eye contact. She did not acknowledge their presence. A photographer captured the moment, and the image has become iconic, shared across social media and news platforms, a visual representation of how the powerful treat those they are supposed to protect. Survivors standing with hands raised. The Attorney General's gaze directed anywhere but toward them. The reaction to this moment has been remarkable in its bipartisan nature. This is not a left versus right issue. This is not Democrats attacking a Republican administration or vice versa. This is people across the political spectrum recognizing an act of callousness and disrespect that transcends partisan boundaries. Republican commentators and influencers express shock and disappointment. One well-known conservative voice called Bondi's refusal to look at survivors insane and shameful. Another described her demeanor as disgraceful and stated there was no excuse for deflecting legitimate questions about why no one in the Epstein files has faced charges. Democratic lawmakers were equally pointed in their criticism. Congresswoman Jasmine Crockett delivered a scathing assessment at the hearing's conclusion. She thanked the survivors for having more courage and moral clarity in their little fingers than the entire Department of Justice. She called the United States a laughing stock due to failed DOJ leadership. She praised Republican Congressman Thomas Massie for being willing to stand up to corruption regardless of party. This kind of cross-party unity is rare. It suggests that what happened in that hearing room violated something fundamental, something that Americans of all political persuasions still believe in: the idea that justice should be blind, that the powerful should face consequences, that survivors deserve acknowledgement and respect. Congresswoman Crockett's critique extended beyond the Epstein files. She raised allegations of DOJ obstruction in investigations of agents who allegedly killed American citizens. She referenced seizure of voter data from Fulton County, characterizing it as election interference. She mentioned federal agents on tape accepting bribes with investigations subsequently dropped. She questioned a proposed payment to the president that she argued violates the Constitution's emoluments clause. Her conclusion was unsparing. She stated that Bondi would be remembered as among the worst attorneys general in history, someone who chose obstruction over justice and loyalty to the president over loyalty to the Constitution. Perhaps the most surreal moment came when Attorney General Bondi responded to questions about the criminal investigation by citing stock market performance. She touted the Dow Jones crossing 50,000, highlighted S&P and NASDAQ records, insisted that Americans' retirement accounts were booming. Lawmakers appeared genuinely confused. Someone asked what the stock market had to do with the Epstein investigation. The Attorney General insisted it was relevant, that the administration's achievements were being ignored. But economic performance is not within the Department of Justice's purview. That belongs to the Treasury Department, the Federal Reserve, economic policymakers. The Attorney General's job is to enforce federal law, prosecute crimes, and ensure equal justice. Her decision to pivot to economic talking points when asked about why perpetrators remain uncharged reveals either a profound confusion about her role or a calculated deflection strategy. New documents continue to surface that raise troubling questions. One file shows Dr. Mehmet Oz, now a Trump administration official, inviting Jeffrey Epstein to a Valentine's Day event in February 2016. This was years after Epstein's initial conviction. Why was someone who would later serve in government maintaining social ties with a registered sex offender? What was the nature of their relationship? Were there other interactions? These are legitimate questions that deserve investigation, but the current DOJ appears uninterested. The path forward depends on whether Congress can work around the obstacles the executive branch has placed in front of them. Congressman Krishnamurthy emphasized that his committee is not relying solely on DOJ cooperation. They have subpoenaed financial institutions to trace money flows. They are preparing to depose Leslie Wexner, the billionaire at the center of Epstein's operation, who gave him power of attorney and allegedly transferred valuable assets for nominal consideration. That deposition is scheduled imminently. They are also questioning the executors of Epstein's estate to understand how wealth was accumulated, moved, and potentially used to facilitate crimes or buy silence. The congressman was explicit about what he hopes to learn from Wexner, not just about the sex trafficking, though that is central, but about all of Epstein's criminal enterprises, the financial schemes, the potential money laundering, the mechanisms by which someone with no clear legitimate source of vast wealth became a billionaire with access to the most powerful people in the world. Understanding Wexner's role is key to understanding the system that enabled Epstein. When asked what message he had for survivors, Krishnamurthy spoke personally. He mentioned his young daughters and his determination that they grow up in a world where such exploitation is not possible. He acknowledged the many ways government failed the survivors and pledged that he and his colleagues would not add to that record of failure. This is the moral seriousness that has been absent from the Department of Justice's handling of this case. But this story is bigger than one case, however significant. What we are watching is a fundamental test of whether American democracy's checks and balances can function when one branch decides to defy them. The Constitution does not work automatically. It requires people in positions of authority to respect its boundaries and fulfill its requirements. When the executive branch can surveil the legislative branch during an oversight investigation, when an attorney general can show up to a hearing with intelligence about what her questioners have been researching, when the agency being investigated can impose restrictions that cripple the investigation, the constitutional structure breaks down. If this precedent stands, future administrations will know they can obstruct oversight with impunity. They can create the illusion of transparency while ensuring damaging information stays hidden. They can turn surveillance tools inward to monitor those who are supposed to monitor them. The party in power may change, but the techniques of evasion and obstruction will remain, refined and normalized, available to whoever holds the executive branch. This is how democracies decay, not through dramatic coups or overt tyranny, but through the gradual erosion of accountability mechanisms until only the facade remains. The survivors at the center of this are owed more than we can ever fully provide. They were failed as children by adults who should have protected them. They were failed by law enforcement that ignored or minimized their reports. They were failed by prosecutors who gave their abuser a deal that was an insult to justice. They were failed when Epstein died under circumstances that remain unexplained, taking his secrets with him. They were failed when files were released with their names exposed and their abusers' names hidden. And they were failed when the Attorney General would not even look at them. But there are also signs of something else. The bipartisan outrage suggests that some boundaries still exist, that some violations still shock the conscience across political lines. The determination of lawmakers like Krishnamurthy and Massey to keep pushing despite obstruction suggests that oversight is not entirely dead. The public attention, the continued pressure, the refusal to simply move on as the administration would prefer, these indicate that the story is not over. The question is whether attention and pressure can be sustained long enough to produce actual accountability. Congressional investigations can expose facts but cannot prosecute crimes. That power belongs to the Department of Justice. And if the DOJ is compromised, if it serves the interests of the powerful rather than the demands of justice, then congressional oversight alone cannot deliver what survivors and the public deserve. It can shine light, but light without consequence is just theater. What happens in the coming weeks matters. The Wexner deposition could reveal crucial information about how Epstein's operation functioned and who else was involved. The financial subpoenas could trace money to places that powerful people would prefer remain hidden. Additional documents could emerge that are too explosive to ignore, or everything could bog down in legal challenges and procedural delays until the news cycle moves on and the pressure dissipates. But even if this particular investigation falters, the precedent being set will remain. The Department of Justice has demonstrated that it can and will monitor Congress during oversight activities. It has shown that it will impose restrictions that cripple effective investigation. It has made clear that it prioritizes protecting the powerful over serving the vulnerable. Future administrations, regardless of party, will learn from this. They will know what they can get away with. And unless there are consequences now, those consequences will never come. In that hearing room, when survivors stood seeking acknowledgement and the Attorney General looked away, we saw a choice being made in real time. A choice to prioritize loyalty to power over service to justice. A choice to protect the system that enabled horrors rather than dismantle it. A choice to evade rather than answer. To obstruct rather than illuminate. To defend rather than prosecute. That choice was made by one person in one moment, but it reflects choices being made throughout the institution she leads, throughout an administration that appointed her, throughout a political culture that tolerates the intolerable when the powerful are at risk. The fight for accountability in the Epstein case is a fight for whether we will have accountability at all in America, whether justice will be something more than a word we recite without meaning, whether the law will bind everyone or only those without the resources and connections to escape it, whether democracy's promise of equal treatment and oversight of power will prove real or illusory. These are not abstract questions. They have concrete answers written in the lives of survivors who deserve better, in the institutional failures that made their suffering possible, and in the choices being made right now by those who hold authority. The survivors stood with hands raised, seeking recognition, demanding accountability, embodying courage that should humble everyone who claims to serve justice. The Attorney General looked away. That image will endure as a symbol of this moment, of this failure, of this choice. And the question now is whether we will look away too, or whether we will keep looking, keep demanding, keep insisting that the promise of justice means something more than protection for the powerful and platitudes for everyone else.